All right, this is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. Are you Brian Keith Taylor appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right. Just a minute. We have to be quiet. This is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so we actually I see over here there's a red jacket. I see them. Yeah. Okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't see any pretrial motions filed, or did you file any?
I did not. I did not see the warrant for any, so I did not file any.
All right. Now, what's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, counsel?
It's protected.
I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point in time, I'm not sure what he wants to do. He's never given me a clear answer.
Before we dive into this courtroom chaos, buckle up, because today's case is the perfect storm of arrogance, ignorance, and one of the most brutally honest judges we've seen in months. You're about to witness a defendant who is so determined to self-destruct, he might as well have entered the Zoom call with a lighter and a can of gasoline. On the other side, we've got a judge who is not here to play pretend lawyer with someone who binged Law and Order and thinks he's ready for the bar exam. This judge is sharp, direct, and has a zero-tolerance policy for nonsense, which is bad news for our defendant because nonsense is all he brought. Not only does this guy reject his attorney's advice, he insists he has motions, plural, while also admitting he doesn't know what any of them are supposed to do. And the judge? The judge is like a prosecutor, a professor, and a disappointed father rolled into one. You'll see him shut down pseudo-legal gibberish with surgical precision, break down basic courtroom procedure like he's teaching kindergarten, and call out the defendant's TV-taught legal fantasies with the comedic timing of a stand-up comic.
So, Mr. Taylor, are you rejecting the plea offer the state made and electing to go to trial? Is that your decision?
The process, this process here, this pretrial hearing, I got motions. I'd like to file.
Well, you're not representing yourself. You have an attorney. And so,
I know that.
Well, wait a minute. Just wait a minute. I'm going to address this. And under the rule, motions, if you have an attorney, only your attorney can file a motion. So if you prepare something that you want to file, I have ordered our clerk's office not to accept those. They will not accept them because you are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake, and you haven't asked for that, and there's be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient and listen, okay? One of your problems may be that you want to speak instead of listen, and that's a big mistake too. So, getting back to my point is that there's not what's called a hybrid representation system in Ohio, and that's a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he has reviewed these with you and didn't find anything that had any legal merit, arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to file any kind of number of motions based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap. So that's where we're at. Now, going back to my question, are you rejecting the plea offer?
Yep.
Yes? Okay, then we will have a trial on April the 7th. All right, so does the state expect this to take more than 1 day?
No, the state expects us to be finished in 1 day.
Okay. And you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses, so I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and respond. Those will due by today, so if you've got them, get it to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, anything else that we need to discuss in this case?
Yeah, I'm going to ask to have my attorney removed, and I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from TV, this is from going through the law book and studying day in and day out. Everything I got the case numbers, case laws, I got.
Motion, what kind of motions are you talking about, Mr. Taylor?
Well, one is a motion to suppress. One is, and I got one here, it's a
motion to suppress, but this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
It'd be.
Well, if you know so much about the law, you should be able to answer that question.
And now that the sponsor segment is done, we're stepping directly into the legal arena. And trust me, this is where the real entertainment starts. Already, the judge is preparing himself for the headache that is Brian Keith Taylor, a man who seems allergic to taking good advice. Before the first question is even asked, you can feel the tension forming. The judge is calm, the attorneys are professional, and then there's Mr. Taylor radiating. I Googled my rights. Energy from miles away. What makes this so fascinating is how quickly the judge identifies the problem. This defendant isn't here to understand the law. He's here to battle it. And the judge? He's about to make it very clear how that's going to go.
I've got an attorney here who knows the law and tells me there's no basis. And now I've got you telling me there is, and I ask you what it is, and you can't tell me.
I asked you to file this motion, and
I know that. I'm saying is, what is it you think should be suppressed and why? What's the legal basis for it that you, being a non-lawyer, has come up with that an accomplished lawyer has not?
got from my paperwork here. How do you organize here at the same time?
So you have an answer. What is it you would seek to suppress?
I don't know.
Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to have my attorney move from the case and have another one, please.
Wait a minute. I'm having trouble understanding. I can hear you.
I'd like to remove my attorney and get another one.
Okay. Well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another court-appointed attorney. I can't afford an attorney.
No, you have a court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, you know, he's not going to do that. So, you know, unless you can tell me why he is not, he shouldn't be your attorney, then you've given me no reason other than the fact that you don't like what he's saying and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything, because a new attorney wouldn't be able to file frivolous motions either. And if I gave you any attorney who knows what they're doing, they're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time. Now, anything else you want to bring up?
Yes, I have grounds, man. I haven't.
I asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
I'm be respectful. Wait till you're done talking.
I'm sorry, what?
I'll be respectful, man. Wait till you're done talking. You got only once for interrupting you.
Okay. I asked you to answer my question, and you didn't when I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that attorney. But I don't know who told you that you're entitled to get more than one attorney, because the court has appointed you an attorney. Mr. Kirk is qualified and competent and experienced and knows way more than you'll ever know about the law. So just because you've been in court a few times doesn't mean you know anything about the law. Just because you got a book you can read doesn't mean you know anything about the law. I could read a book on brain surgery, but that wouldn't make me a brain surgeon. You can read a book on the law, and it doesn't make you a lawyer.
Here's where the tension really starts to crackle. The moment the judge brings up motions, the defendant jumps in like he's been waiting all week to deliver this performance. But notice how the judge immediately shuts it down, not with anger, but with firm, almost parental disappointment. This is textbook courtroom procedure. Defendants cannot file their own motions when they have counsel, and the judge wastes zero time explaining why. What's especially funny is how Mr. Taylor insists he has motions, plural, yet can't articulate a single legal basis for any of them. This is a perfect example of someone who knows just enough to cause problems, but not nearly enough to solve them.
Now, any other things you want to bring up, Mr. Taylor?
Represent myself.
Well, that would be the biggest mistake you've ever made in your entire life. Based upon what you've been telling me, I don't think there's any way in the world you could represent yourself. Pardon me?
I haven't been able to tell you nothing.
I can't understand. You're mumbling.
I haven't been able to tell you anything.
Well, you're not the attorney. You know, you're on trial. You don't get to participate in your defense, because that's what an attorney is for. That's why you have one.
But am I allowed to have a fair and just defense?
Oh, absolutely, and that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
I don't have all my discovery. I'm missing 12 things that I'm undiscovered. I'm begging for.
Well, he's got the discovery. Well, let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, I mean, my understanding, he's given you more than what most defendants get in these kind of cases, because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of the what they say are the buys, right? And then you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kirk?
That is correct, yes.
All right. So I don't know what you're talking about when you say you don't have discovery, because you've got everything that he's got.
At this point, the judge has laid out the rules as clearly as possible. No hybrid representation, no filing motions while represented, and no legal fairy dust that magically turns YouTube tutorials into valid case law. Yet Mr. Taylor keeps doubling down. What we're seeing is a classic courtroom clash between reality and confidence. The judge is walking him through basic, foundational principles of criminal procedure, and the defendant is responding like he's being denied a constitutional right that doesn't exist. The judge even hints, politely, for now, that this strategy is shaping up to be a colossal mistake. And it's only going to get worse from here.
And that's it. Discovery is what he's giving you what he has.
My discoveries don't even have counsel eyes only stamped on them.
It doesn't have to have a stamp on it. It's done by email.
And same time, I get a piece 1 week, I get a piece 2 weeks later, and I get a piece Monday.
All right. Well, good. It gives you something to do. So what? We still got 10 or 12 days to try. But again, you're not going to be the one that's going to be questioning the witnesses and presenting evidence and making arguments. That's what your attorney does. Pardon me?
Well, I'm afraid of.
I would be afraid too if I were on trial, but that's not why we're here. This is a final pretrial, and we're ready to go to trial. The court, we're going to send out our jury notices today. State's ready to go, and you're going to be ready to go unless you get a new attorney. And again, you're not going to get maybe you can find somebody to be willing to take the case and go to trial on the 7th. But that's going to be on you. If you want another attorney, you can get one. But all this stuff you're telling me doesn't amount to a hill of beans, as my dad would say.
I represent myself.
Pardon me?
I represent myself.
Well, if you want to do that, how are you going to do that? What do you know about the law?
I don't know that much about the law.
And so you want to go to trial not knowing much about the law against a prosecutor that does know the law?
I think my percentages would be higher, yes.
Pardon me?
I think I would have, my percentages would be higher, yes.
Well, I can't understand what he's saying.
Yeah.
He said his percentage would be higher. His percentage of winning would be higher if he...
Oh, yeah? What do you think that would be?
I don't know.
Well, give me the odds. I'll take that bet. Because you're absolutely 100% wrong. Everything you're saying here is exposing the stupidity of your position. And for me to allow you to represent yourself will be guaranteeing you a conviction. You'll be getting convicted of everything. You don't know what you're talking about.
This might be one of the funniest and saddest moments in the whole exchange. The defendant claims he has a motion to suppress, which sounds impressive until the judge asks the most basic follow-up. What are you trying to suppress? And suddenly Mr. Taylor transforms from a confident legal scholar into a confused student caught cheating on a test he didn't study for. A motion to suppress is a highly technical legal tool. It needs a specific factual foundation and a clear legal argument. But here, the defendant doesn't even have a sentence, let alone a theory. Watching the judge push gently for an explanation while the defendant offers absolutely nothing is peak courtroom comedy.
Have you ever picked, do you know what the word voir dire means? Okay. Do you know what the separation of witnesses is?
That's one of my motions to seven.
Well, we don't get, separation of witnesses, I ask you.
Yes, yes.
Okay. So what is it?
Five.
Huh?
Motion I asked him to file.
Okay, well, that is filed at the time of the trial. When we start the trial, that's an oral motion. What kind of a motion did you want him to file?
You have to give me time to get it.
No, you're the one that claims to know more than he does. You should have been prepared to tell me. If you've got all these arguments, don't tell me you got to sit there and try to figure this out, because we're not going to sit here all afternoon. You tell me what it is you wanted him to file. You just told me you wanted him to file something. Tell me what it is you wanted him to file. Don't tell me you got to go look for it.
I'm pretty organized here.
Well, why can't you answer the question then?
Because I can't tell you without.
Okay, well, look at it. You should be able to find it. I'll give you 15 seconds. Find it.
File a motion for the rest of my discovery.
There is no other discovery to file. Again, you cannot. Pardon me?
I got a list here.
What?
I think he's basing his list off of other
No,
people.
I'm not.
Because he thinks there's a set number, sir. He thinks
Listen, be quiet. Let me hear what Mr. Kirk's saying. Go ahead.
He thinks there's a set number of discovery items. I've told him that is a myth. Some people may have 14. Some people may have 2. And I've explained that to him. However, he does not trust my advice on that. I do not believe he's missing anything other than there is a lab report that was just filed that I will be taking out to him. But he thinks there's some sort of mythical set number of items.
Okay.
Judge, I can probably shed some light on this as well.
Go ahead. No, without to.
Some defendants believe that they should have copies of the buy money, for example. In this particular defendant's case, those are actually pictures that were on the digital evidence that he would not have access to out there because he's in jail.
Right, I understand.
There are several things that are digital evidence that he physically cannot have access to because he's in jail.
Okay. Well, your attorney has those, and he's shown them to you, as I understand it, right?
Yes, oh yeah, he showed me the digital stuff, but he has showed me, yes, right. But also, if they're going to have PCI experts on the stand, and we get a chance to cross-examine them, shouldn't I have their qualifications and all that for cross-examination? Also,
Cross-examination would be based upon their report.
Also, the submission report to the BCI lab, I don't have, and I don't have the physical evidence or the witness. I got the witness list. I don't have the CI's felony report. I don't have the forfeitures. I don't have disclosure of all evidence and everything from them.
Well, your attorney has it, and he has it, and he's discussed it with you. You don't have to have all that with you in jail. I don't know that you'd have room for it. So,
That doesn't exist.
Pardon me?
A lot of this that he's talking, so he just said he doesn't have a list of the forfeitures. There are no forfeitures in this case.
Oh,
He
well,
has
there would
the
be. Yeah.
CI's. He has the CI's criminal history. He just doesn't know how to read the discovery.